Thank you, Senator Johnson. I'm Clint Lancaster. I'm just here because I don't like this bill, and I wanted to tell you why. First of all, before I do that, I wanted to thank you for doing a tough job today in conducting this meeting and hearing everybody's strong opinions. I think the only way it would be more controversial in the hearings if you want to change the name of the Razorbacks to the, puppies of the pool or something. And Senator Hester, I appreciate your passion for what you're doing. It's very clear that you believe a lot that what you're putting forth here is what's best for Arkansas. And I've heard today a lot of people say, yourself, Senator Johnson, and Senator Hester, that people want government to work more efficiently. Well, government in and of itself is pretty efficient as it is. And I don't know that changing this would really improve that efficiency ratio, but I do know that it would change the transparency ratio. And I, just as a citizen of Arkansas, I would rather my government be more transparent and efficient, because I can at least know what's going on. I wanted to talk about the governor's security. I'm concerned that people want to hurt the governor. I'm concerned that people want to hurt anybody. And I think that it's right to protect the governor. I don't think that protection, I agree, we shouldn't be giving out the routes, and we shouldn't be able to see how the state police is doing training to protect her. I don't even want to know the state troopers' names. I like the state troopers even when they write me speeding tickets on the interstate. And so, but what I do think is important is knowing who the governor is associated with when she's traveling. I think that if she's on a plane to Europe with Ron DeSantis, I'd like to know that. And that's kind of what I think. As far as the other things that are on there, some of my main concerns are the working papers exemptions. We're talking about the cabinet secretaries. So I think we're all overlooking what's called agency theory. And just if you forgot, I am a lawyer. Agency theory says it's got two prongs to it. An agent must have the authority to act for the principal, and that the agent act on the principal's behalf and subject to the principal's control. So this is how I think the Supreme Court would interpret this. They're going to say if that cabinet secretary forwarded that email to someone that works for him or her, then, and they're doing that in that capacity, that privilege, that exemption is going to cover that because that's the agent. And that's not clearly spelled out in the bill. The law is that the Supreme Court says if they made a ruling, you know about it. And so you would have specifically made a language that would have accepted that. So if you're going to keep that, I don't like it because I want to know how my government is functioning. I want to know what's being said. But if you insist on keeping that, I would really strongly urge you to add more language to make sure that the agency theory does not apply. Because if not, you're just going to dilute the whole thing. I don't think it will function like you're expecting it to do. I think that the attorney-client language that's in there, I'll tell you, I've been in litigation with the state. In fact, I lost one yesterday against the state. And at no point could I have attempted to get, I could have attempted, but I would have never gotten what the Attorney General and the Secretary of State talked about. What that advice was or anything else. You don't have to create a statute to exempt that because that's already how the judiciary interprets that. The same thing is true about the work product. I've never been able to get the work product of any other attorney, much less the government, even when I do a FOIA. And I don't do a lot of FOIAs very often. So I don't think that we should be in the business of fixing something that's not broken. And finally, on the attorney's fees issue, nobody in the legal industry is getting rich on FOIA cases. Okay? Nobody. If that was the case, you'd have billboards up and down the interstate telling you why I'm the best FOIA lawyer and all that stuff. I will tell you that it's always possible, like Senator Tucker said, and I agree wholeheartedly with Senator Tucker's statements today. If you have a problem with somebody's abusing the process, you have a remedy for that already. It's Rule 11 of the Arkansas Rules of Civil Procedure on motion for sanctions. If that person has brought a frivolous lawsuit, the judiciary already interprets that. But the catalyst effect is correct. I've been able to get a lawsuit with some county clerks who didn't want to provide me anything until we got to the courthouse. And without that ability, you know, it's just not something that's enforceable. So I would just ask, I have reviewed Representative Mayberry's bill. I believe that it is within the call of the governor, and I support, I think Senator King is a co-sponsor. I like that because there's less.
So there is a conservative alternative to this.
Protection for the governor without having potential problems that come in. And so with that, I thank you all for your patience today and for the work you do for the state. I'm closed, and be glad to take your questions.
So, you said there was, you know, your question